I'm John Condello. I'm going to do my best to share with you in a very brief manner non-service connected disability pension and DIC. And then Diane's going to talk with you about requirements to represent before the VA for licensed attorneys. So, non-service connected pension. I want you to think about two types of relief. When somebody walks in your office, here's the drill. Here's what you're going to do. You're going to receive them, you're going to look at their discharge papers. The key is they've got to have some kind of paper, or if not, you're going to help them file an SF-180 with the NPRC, the National Personnel Record Center. Without proof of service, you cannot file a claim with the VA. So you're going to look at those service papers once they're received, and you're going to look at two pieces. One is what Diane was talking about, which is the real foundation of VA benefits, and that is service-connected. Something happened to you in service, the three legs of the claim. Something happened in service or is traceable to service. You have a condition right now, same condition or something related to it, and there is a medical nexus connecting them. That's service-connected. Here we're looking at non-service connected. This is for wartime veterans. So historically, we'd only be looking at limited periods of war, World War II, Korea, Vietnam, but now we've got, since about 1991, we have about the 30 Years' War. We have from 1991 all the way to a period yet to be set and determined by Congress. That's really good for your client. Anybody that served from approximately 1991 on, in theory, is eligible for non-service connected pension. So let's take a look. Monetary benefits are provided to vets who are totally and permanently disabled. To be eligible, the vet's got an eligible discharge, honorable general, or under honorable conditions. Served during a wartime period, that's the key. Now, you didn't have to be in the field of battle. You didn't have to be deployed in country, say to Vietnam. But if you served during the Vietnam War and you are totally disabled for whatever reason, then theoretically you are eligible for the non-service connected pension. Meets the minimum duty requirements. Now that's important. After about 1982, it's 24 consecutive months of active duty service. Okay? So meets the minimum duty requirements. One way you can get around that. What if you had a guards person and they didn't serve 24 months on active duty? What if you got them 10% rated for, say, hearing loss as a service-connected condition? Once they're rated for hearing loss, they are considered a veteran for VA purposes. Well then, what if that same veteran is totally disabled other than his hearing loss or her hearing loss? Theoretically, you're going to meet the minimum duty requirements by the fact that you got them rated as a veteran. So there's other ways to get in as a veteran even if you don't meet the minimum service time. That may be a little complex, but primarily minimum duty requirements are going to be 24 consecutive months active duty after 1982. Has a total and permanent disability not due to willful misconduct. So we already talked a little bit about willful misconduct. I'm not going to go into that any further at this point. Is low income and has a net worth which does not provide adequate maintenance. So really, this is a safety net for wartime veterans who are living at the poverty level, who are totally disabled, unable to care for themselves. And the pension, NSC pension, pays better than SSI. So it is very much worth your while to explore these with a client who's low income and served during a period of war. Note, a veteran cannot receive pension and compensation simultaneously. Where a veteran qualifies for both, VA will pay the higher amount. Now, I'm not going to get into these fact patterns too much, but theoretically, your client might decide that he doesn't want pension, even if he qualifies for it at some point, as he's trying to get his service-connected conditions up a little bit. What if he gets to the 30% level and he no longer wants pension because it's income-based? There are a lot of distinctions. But unless you tell VA otherwise on behalf of your client, they will pay you the greater of the two. And a lot of the times you've got a person with 10 or 20% comp, and then NSC, non-service connected pension, which is going to pay more than that. Okay, vet must have served at least one day during the following: World War II, Korean conflict, Vietnam, Gulf War. Okay, so We've got at least 1 day during the following. Okay, that's the standard we're showing here. Active service must include 90 days during a period of war, or at least 90 consecutive days, one of which was during a period of war, or at least 1 day of wartime service, and the vet was discharged. That's the one I was getting at. It was discharged for service-connected disability. Vets who enlisted, there we go, who enlisted after September 8, 1980 must have, there it is, 24 months continuous active duty, full period for which was called or ordered to active duty. So if you were called up and you didn't serve 24 months, if it was your full period and you've got a DD-214 for it, then you would qualify. Okay, these are the need-based benefits. Okay, income for a single vet with no dependents must be less than $13,535 a year in 2019. That's not a lot of money, especially in Hawaii. Medical expenses, this is the key, can be deducted from total income if they're greater than $676 per year. If there's a spouse, income must be less than, I'm looking here, I'm thinking $17,724 per year. Yeah. Okay. Net worth must not be excessive. Basic necessities like a house and a car may be owned by the vet, but not a lot more. One of the keys here is if there seems to be more income, take a look at those recurring medical expenses. A lot of times, if you can document recurring med expenses, you can get your client eligibilized. But the key is always remember, every year you're going to have to be filing those financial status reports. If it turns out that income changes, or especially in terms of income will change if those medical expenses did not recur, theoretically, then you can lose eligibility. So you've got to be really diligent with your client to make them report every year if those expenses have changed. Otherwise, you can find your client in an overpayment situation, and that can be problematic because then it's going to reduce the amount of money your client can get every month until the overpayment is repaid. Okay. Disability can be due to conditions acquired at any time, in or out of service. So the key with this need-based program for wartime vets is it doesn't matter how you became disabled. It's like SSI. The vet must be unable to work due to his or her medical conditions. Automatically qualifying vets if other conditions are met, this is a key. Veterans 65 and older are presumptively disabled for purposes only of non-service connected pension. Now, a question people often ask me is, well, does that mean if my client who's going for service connection is looking for unemployability, does age 65 disqualify from work? Does it say you're presumptively unemployable? The answer is no. And we're going to get into IU later, unemployability. So the 65 only applies when we're looking at non-service pension, but that's a really useful number. I've had numerous vets who, a lot of them were Korean War. This was years ago. They turn 65, they're presumptive. You don't have to show they're totally disabled. The age 65 does it. And people are living on the streets, and they get this, and it makes a difference between having a small little place and maybe eat as often as possible, or not. So this is really awesome, the 65. Patients in a nursing home receiving skilled nursing care. This is very important. And the current paperwork is going to account for that, allow you to start disclosing those kind of things, and that's extremely important. All disabilities are considered under the schedule of ratings. 100% disability by the schedule is equivalent to total disability. Other combinations of ratings which satisfy a finding of unemployability for service-connected benefits will also show total disability. So if there's a number of things wrong, what we're really saying here is if there's a number of conditions wrong and they render your client unemployable, if it's not service connection in this case, it doesn't matter. It simply matters that the magnitude of the total conditions renders your client unemployable. And you don't always have to fight for this. VA has generally been pretty good about allowing non-service connected pension. The key piece to remember though, if you can get your client connected for NSC pension, kind of a foundational welfare kind of a program for wartime vets, remember this, if that income changes at any time, say they take a part-time job, that's going to throw them out, or at least it could throw them out. So you've got to be really careful that your people don't remove their eligibility by doing things that they shouldn't, especially work. If other conditions are met, disability findings may be by Social Security Administration are conclusive unless there's something totally to the contrary. So if you've got a Social Security disability rating findings, you can use that as good evidence with the VA. Right, Diane?
This is true, although I've noticed VA is supposed to request the Social Security file. They're not requesting the findings anymore. They're only requesting the medical records.
Yeah, I believe it. So the practitioner has to get the findings and submit
Exactly,
them.
exactly.
So that's a key piece to remember. Okay. Compensable disabilities which cannot also be service-connected. So we've got congenital and developmental birth defects, personality disorders, intellectual limitations, mental retardation.
This is where the personality disorders come in.
Oh yeah, oh yeah. So you certainly cannot be rated for personality disorder if there's a bona fide one. They're not going to rate you for birth defects. Intellectual limitations. The only thing I can think of with this one is like McNamara's 10,000. You know, during the Vietnam War, they decided to allow people in the service with extremely low IQ scores. Those people then later suffered a lot of indignity in the service because they just couldn't meet the intellectual needs of being a soldier. So you could probably argue things that happened to that soldier in service. You couldn't argue the intellectual limitations themselves. So let's take a look. Disability pension payment rates. Pension rates for a single vet in 2019 are $13,535 a year. And it increases with dependents. One dependent, $17,724, and $2,313 for each additional dependent. If you're housebound with no dependents, you're going to get $16,540 a year. If you're in need of regular aid and attendance of another person and you've got no dependents, $16,540 a year, and in a skilled nursing home as well. Okay. DIC. Now this is a very, very useful program, dependency and indemnity compensation. I just want to kind of give you an eyeball view of it. A veteran dies of a service-connected condition. Let's say, typical fact pattern, Vietnam veteran who has diabetes, prostate cancer, maybe they manifest lung cancer. These are all presumptive diseases for Agent Orange on the ground in Vietnam or now in the blue water within 12-mile nautical limit of Vietnam. If there's a veteran who's rated, let's say for diabetes, and diabetes appears on that death certificate as one of the causes of death, the spouse then can go in and apply for what's called dependency and indemnity compensation, which would give that spouse approximately, what is it about? It's about $1,200, $1,300 a month the rest of their life, as well as commissary privileges and Champ VA medical, as well as educational benefits. So it's very, very useful. Let's take a look here. To be eligible, also, I want to say this. If they die of a service-connected condition, that's a key, or if they are 100% total and permanently disabled for a period of 10 years.
So the spouse of the deceased veteran can get educational benefits?
Yes. Yeah, we can talk about that a little more as we go. Yes. So the spouse must have been married to the vet for at least 1 year prior to death, and the vet's primary or contributing cause of death was a condition that was service-connected or can be service-connected after death. And I've done this with presumptive conditions, such as Agent Orange-related presumption. A typical veteran often never applies for benefits, and he ended up dying of lung cancer, and he served on the ground in Vietnam. That's a presumptive disease. We can actually go in and seek relief for that spouse, and we can get it, provided we can prove the veteran was boots on the ground in Vietnam or now in the blue waters within 12-mile nautical limit. The vet, and just like I said earlier, the vet, either they died of a service-connected condition or the vet had 100% service-connected disability for 10 years prior to death. Now that includes individual unemployability. And I'm going to tell you about unemployability as we go, just to kind of tell you what it is in a nutshell. If you can't work due to your service-connected conditions, if you meet certain criteria, you can still be paid at the 100% total permanent disabled rate. The kicker is you can't work afterwards. So if you die of 100% service-connected disability, or for something you're rated IU for, unemployability, the spouse can be eligible for DIC. DIC rates for a survivor without dependents in, it looks like 2017 there, started at $1,319.04 a month. This amount is increased if at the time of death, vet was totally disabled for 8 years prior to death, overlapping 8 years of marriage. If so, we add another $326 to that total. For dependents, we add $326.77 a month for each dependent. If a spouse, if a widowed spouse is housebound, you add $153.08. And there's an examination sheet for regular aid and attendance and housebound. Need of regular aid and attendance on another person to see to the daily needs of life, to care for his or herself with bathing, clothing, preparing meals, etc. Regular aid and attendance, you add $336.77 a month. And also if the person is in a skilled nursing home. The survivor should file an application. Now we got here 21,585 ARE within 1 year, so benefits go back to the veteran's death. Claim for Social Security survivor benefits must also suffice. So what they're trying to say here is you're going to do your best to file for accrued benefits, right, Diane? Yeah, that's it. We're looking for accrued. So basically, you want to go back to the time when the veteran died and get all those benefits that were due. In addition to the other payments, if the vet had been entitled to but not paid VA benefits before death, surviving spouse can be paid accrued benefits. That's what we're looking at. Spouse can be substituted for the veteran to argue claim. As of 2016, spouse is no longer limited to the evidence that was in vet's claim file. So basically, a veteran's got an appeal going for several conditions. The veteran dies during the pendency of that appeal. The spouse can step into that veteran's shoes, and typically you'll take a power of attorney for that spouse and you'll file the proper forms, and the spouse will actually litigate that appeal or the active benefits case and seek all those benefits that were due from the date of claim all the way to the date of death. If the spouse can prevail, they'll get all those benefits. That's a very useful claim. Now this is a key law because when we first started doing this, the spouse was limited to the record on hand at the time. That really ties one of your hands behind your back because typically VA appeals and claims are really open in terms of evidence, as they should be. That old law prevented a spouse from filing additional information that she or he could find. So now we've got open evidence, just like it would be for the living veteran. So that's a really substantial change in the law. Okay, now Diane's going to go on requirements to represent vets before the VA.
So this is part of the 3-hour accreditation. So these are things to know. If you want to rep vets before the VA, you have to be accredited. So some of you may have already done this. I don't know how long it's taking these days. You guys might know.
When I signed up, it was actually really fast.
Yeah, it was for me too, but that was 2009.
Yeah, that was like 2 years ago.
Well, I just signed up. It took like a day.
Oh, wow.
I did it on a Friday and I got it on a Monday.
Oh, that's crazy. That's even quicker than it was for me.
That's weird.
So fill out a VA Form 21A, mail it, fax it, email it to the VA Office of General Counsel, and wait for the word that you're accredited. So apparently the word's coming pretty quick. Okay, so then you have to take this 3-hour CLE, which is this 3-hour CLE. And until this is complete, you can't rep vets. But you can advise. Okay, so to keep this accreditation, You have to keep doing these exciting CLEs. I will say there are CLEs on the mainland as well. I tend to go to the ones for the National Organization for Veterans Advocates. I think this year they're in Atlanta and Cincinnati, Ohio. But annually you have to let the VA Office of General Counsel know that you're still in good standing with the bar, or if you're a military wife, all the bars that you've taken. You also have to certify that you've done your CLE. And that's as easy as, you actually don't have to get the certificates of good standing, which is fantastic. I didn't know this right away, but you don't. You can just write a letter saying that you're still in good standing and you did CLE. You don't have to give any proof unless they ask for it. Okay, so this is every veteran's case you take, you have to let VA know that you took it. So you need to enter into a VA Form 2122A with the veteran. They sign it, you sign it. You send it on off to VA. It'll specify what you're representing them for. So you can say things like, I'll represent them before the VA, but not the Court of Appeals of Veterans Claims, something along those lines. You submit it to the regional office. That's how VA knows that you're the rep. May take more than one submission. They've been pretty good these days, kind of. If you plan to charge a fee, so there's new rules, old rules. Under the old rules, it was you had to wait until the notice of disagreement was filed. The new rules, you have to wait for the first adverse decision. After the first decision comes out, you can actually charge a fee. The fee, if you want VA to pay it, will be 20% of the back pay. And what that means is, if you win your case, theoretically, what will happen is VA will calculate how much they owe the veteran in back pay. So they'll calculate what they should have been paying them all along, and they'll put 20% in your bank account and send 80% to VA. The reason I'm saying theoretically is this still is not working fantastic. It's working better than it was. Sometimes you'll get it, sometimes you won't. I don't see it. Oh, yeah, it is on this page. You must submit your fee agreement to the VA regional office within 30 days. That's part of the hiccup. The great thing now is we can go online, provided you've got your 2122A in, you can go online and you can look in the veteran's file and you can see when they actually filed your fee agreement. I've had this happen quite a few times. You send it to VA within 1 day and they file it in the veteran's case 45 days later. You win the case and then you don't get paid. So you want to go in and make sure that they have filed your fee agreement within 30 days of your sending it, or they won't pay you. You also have to limit it to a reasonable fee. So you can also do the thing which most attorneys are familiar with, where you actually charge your client directly. You can put it in your IOLTA account, that whole deal. You're limited to a reasonable fee. So VA still has power over you to tell you you can't charge that. You're charging too much. So you still have to send your fee agreement in. They're just not withholding the amount. You're getting it from your client. 20% is presumed reasonable. Over 33% is presumed unreasonable. You can add out-of-pocket costs, the cost of medical records, cost of travel, whatever your out-of-pocket costs are. And that's actually it. Did anyone have any questions about what I just said? Okay. Did anybody have any questions about what John said?
Oh, we're going to do discharge upgrades.
No, that's not actually part of the accreditation CLE. So we didn't stick it into the 3 hours because the 3 hours is so much information that we didn't put anything extraneous in there.
But we will be talking briefly about adjudication of service as honorable for VA purposes. Right, Diane? We will have a bit of
Yes,
that.
yes.
Just a bit of it. And so there's a distinction. You can get a person who's got a first full term of service adjudicated as honorable strictly for VA purposes by the VA. That's an administrative decision. It doesn't change the character of discharge, but it allows the veteran to have the dignity of VA services based on earlier honorable service. And we'll talk about that at some point today.